So let's talk about AB2257, right? AB2257, sweeping changes to AB5 independent contractor law. Businesses operating in California have had all of 8 months to adapt since Assembly Bill 5, a landmark piece of legislation governing their relationships with independent contractors, took effect on January the 1st, 2020. Now, with the passage, executive signature, and immediate enactment of Assembly Bill 2257, businesses must once again adapt to another drastic shift in the employee classification calculus. On September the 4th, 2020, AB 2257, which substantially revises and clarifies California's independent contractor laws, went into effect immediately upon receiving California Governor Gavin Newsom's signature. AB5, as businesses are all too aware, installed the ABC test as the default standard to determine whether independent contractors should be treated as employees of a hiring entity, and also set forth a labyrinth list of exemptions from its purview. From its inception, AB5 has stirred an inordinate amount of controversy. Not only have we written extensively on the measure, we also have our own tag dedicated exclusively to the issue. Our prior analysis of AB5 can be assessed here. AB5 2257, which preserves the ABC test for independent contractor classification, now expands the universe of available exemptions from this test. The new law will no doubt delight some businesses, frustrate others, and confound anyone responsible for keeping track of the exemptions. Background of AB5. I think we know most of that, right? AB5 expanded the reach of Dynamax by making the ABC test the default test for all labor code, unemployment insurance code, and wage order claims. As a result, the ABC test extended to a host of additional causes of action not previously covered, such as, for instance, claims or failure to reimburse necessary businesses' expenses and for failure to provide accurate wage statements. AB5 also contained numerous statutory exemptions from the ABC test, provided certain criteria were met. The unemployment status of independent contractors in an occupation covered by one of these exemptions was determined by the common law test for unemployment, commonly known as the Borrello test, a considerably more flexible standard than the ABC test. The fact that some industries were expressly exempted while others were not led to controversy, confusion, and requests from hiring entities and workers in dozens of industries for additional and clarification legislation. As of February of this year, the legislator introduced 34 standalone bills exempting certain industries. As for those measures wound through the legislative process, they were for the most part distilled in AB 2257. What's new in AB 2257? AB 2257 maintains the essential framework of AB5. The ABC test remains the default standard for independent contractor misclassification. However, swift and concerted lobbying efforts have prompted a plethora of new statutory exemptions from the ABC test, which apply retroactively where applicable. In addition, some existing exemptions have been altered in potentially significant ways. Business-to-business exemption, AB 2257, maintains the exemption for bona fide business-to-business contracting relationships where a contractor acting as a sole proprietor or a business entity formed as a partnership, limited liability company, limited liability partnership, or corporation contracts to provide services to other such business. The exemption now also applies where a public agency or quasi-public corporation has retained a contractor, further while broadening The availability of the exemption AB2257 might also affect how the ABC test applies to individual workers retained by a contractor with respect to their relationship with both the contractor and the hiring entity. For example, the ABC test might determine whether an individual worker retained by a contractor as an independent contractor and not directly by the hiring entity is an employee of both the contractor and the hiring entity. While case law holds that the ABC test does not apply where a worker has been classified as an employee, the unclear phrasing of the new business-to-business exemption could lead to litigation on the subject, and that'll probably come. Single engagement business-to-business exemption, AB2257, creates an exemption from the ABC test for individual business persons who contract with one another for purposes of providing services at the location of a single engagement event, provided certain criteria are met, including lack of control over the work, a written contract specifying payments amounts, and each individual's maintenance of his or her own business location. The ABC test will not apply where one individual contracts with another to perform services at a standalone non-occurring event in a single location or a series of events in the same location no more than once a week. Referral agency exemption, AB2257, also includes clarifications of the referral agency exemption, which may exempt from the ABC test the relationship between an individual operating as a sole proprietor or a business entity and a business that refers that individual services to clients. For starters, AB2257 expands the referral agency exemption significantly, expressly applying the exemption to a non-exclusive list of additional services. Now, I will put the link underneath this video, just letting you know, including consulting, youth sports coaching, caddying, wedding or event planning services provided by wedding and event vendors, and interpreting services, according to the Senate Committee on Labor and Employment Analysis. The referral agency expansion was one of the most significant changes in AB 2257. In addition to expanding the scope of the exemption, AB 2257 expressly provides that the ABC test governs the determination of whether an individual worker is an employee of the contractor referred to provide services or an employee of the client to which the contractor was referred. As with the analogous clarification of the business-to-business exemption, this is potentially significant addition that it may lead to litigation over whether the ABC test applies to workers who have been classified as employees. Professional services exemption, AB 2257, expands the already lengthy list of occupations that may qualify for an exemption from the ABC test under the professional services exemption. The following occupations, in addition to those originally identified in AB5, may be subject to the common law test for employment as a result of AB 2257. Content contributors, advisors, producers, narrators, or cartographers, or certain publications, provided they do not displace existing employees. Specialized performers hired to teach a class for no more than a week, appraisers, registered professional foresters, and home inspectors. AB 2257 also eliminates restrictions in AB5 that threaten to upend the journalism industry, whereas AB5 limited the number of submissions that independent contractors of various types, including still photographers and photojournalists, videographers, photo editors, freelance writers, translators, editors, copy editors, and illustrators, newspaper cartoonists, could publish in a single forum without sacrificing their contractor status. AB 2257 removes the submission cap and instead requires that businesses refrain from displacing existing employees in order to utilize one of these types of contractors. Music, industry, and performer exemptions. AB 2257 creates several exemptions for the entertainment industry, primarily in the music industry. First, the following occupations involved in creating, marketing, promoting, or distributing sound recordings or musical compositions are exempt from the ABC test. Recording artists, songwriters, lyricists, composers, proofers, managers, or recording artists, record producers and directors, musical engineers and mixers, musicians, vocalists, photographers, independent radio promoters, and certain types of publicists. Notably, however, musicians and vocalists who do not receive royalties from a sound recording or musical composition must be paid the applicable minimum and overtime wages as though they were employees. Second, musicians and musical groups engaged for a single where is this here? I see. Notably, however, musicians and vocalists who do not receive royalties from a sound recording or musical composition must be paid the applicable minimum and overtime wages as though they were employees. Sound musicians and musical groups engaged for a single engagement live performance event, i.e. concert, are exempt from the ABC test unless they perform a symphony orchestra or in a musical theater production or at a theme park or amusement park, or an event headliner in a venue with more than 1,500 attendees, or perform at a festival that sells more than 18,000 tickets per day. Finally, individual performance artists, including comedians, improvisers, magicians and illusionists, mimes, spoken word performers, storytellers, and puppeteers who perform original work they created will qualify for an exemption so long as they are free from the hirer's control, retain the intellectual property rights related to their performance, set their terms of work, and negotiate their rates. Miscellaneous exemptions. Subject or certain requirements. AB2257 adds exemptions for the following occupations: manufactured housing, salespersons, certain individuals engaged by international exchange visitor programs, and competition judges, including amateur umpires and referees. Broader government enforcement powers. AB2257 provides district attorneys the ability to file an injunctive relief action against businesses suspected of misclassifying independent contractors. Previously, only the Attorney General and certain city attorneys possessed this power. So that's a big change. Which industries were excluded from AB2257? AB2257 does not include exemptions for a number of industries that have engaged in extensive lobbying efforts that predate even the passage of AB5. Such industries include, amongst others, gig economy companies, franchising, trucking, and the motion picture and television industries. The 2021 to 2022 legislative session will undoubtedly see these and other industries lobbying for additional exemptions. The most immediate task for many of the business in the business community, however, is understanding how AB2257's amendments affect their business relationships, right? So the industries that were excluded by AB2257, obviously the gig companies fall into that. So that's a big thing here. What will happen next? AB2257 took effect immediately upon its passage and is accordingly the law of the state of California. It is given that some industries that did not secure an exemption may continue lobbying legislators. Others may choose to follow the lead of transportation platform companies, which are funding a ballot initiative, Proposition 22, to create a new class of workers applicable to drivers. If their efforts prove successful, lawsuits currently pending and yet to be filed, including one previously filed by a trucking industry interest group, may yet affect the scope of AB2257's application. Finally, it remains to be seen whether governmental officials will avail themselves of the enforcement powers bestowed upon them, as the flood of such lawsuits predicted by many following the passage of AB5 has not occurred. Workplace solutions, as usual, navigating the constantly changing legal landscape for independent contractor status can be very complicated. If your business uses or is thinking of using independent contractors to assist with any business functions, make sure you contact your favorite SafePath attorney or reach out to members of the independent worker strategy team to make sure you are staying compliant with the latest legal developments. So the big part here is that which industries were excluded from AB2257, the gig companies. And I will put the link. It's a pretty dry sort of legal video, I understand that, but you know, this AB2257 does really affect a lot of people out there. So you need to know what these sweeping changes are. Have a great day, and thank you for watching. Your comments, please.